Good morning, everyone, and welcome to the P2B Regulation webinar. It's just past 11:30. We're going to give another minute or so for a few more people to join. So if you just wait for us for another minute, we'll get started. Thank you. Okay, thank you for joining us this morning. My name is Judy Krieg, and I'm a partner in the Field Fisher Privacy Team. And this morning, Dr. Kwan Han and I are going to talk to you about the P2B regulation. Just when you thought it was safe to get back in the waters after GDPR, now we've got to deal with P2B. So, given the fact that we are not able to be with you in person or have our cameras showing, we thought we'd put some faces to the voices. So on the left is a photo of Kwan. Kwan, would you like to briefly introduce yourself?
Hi everyone, I'm a director in the Privacy, Security and Information Law team at Field Fisher in London, but I do tech law more broadly, as you can tell from this presentation.
Thanks, Kwan. And I'm the face on the right with the perfectly colored hair, which of course, needless to say, is existing only in pictures these days. But I'm a partner in the same team in London. And so we want to talk to you a little bit about what is P2B and do you need to worry about it since it is coming into law in July. So without further ado, we're going to talk about four different points today. First of all, we're going to give you a very, very high level overview of what is the P2B regulation so you can put it all into context. Then we're going to dive right into what online platforms are in scope. We're going to then talk about for online platforms that are in scope, what do they have to do to comply? And then we're going to finish up with a checklist of actions for platforms that are in scope and do need to think about these things before July 12th. So, first of all, what is the P2B regulation? Technically speaking, the full name is Regulation EU 2019-1150 of 20 June 2019 on promoting fairness and transparency for business users of online intermediation services. That is a mouthful. Therefore, we are referring to it, and it is known as the Platform to Business or P2B regulation. It does go into effect on the 12th of July, so a little bit more than a month from now. And even though technically search engines are also in scope for the P2B regulation, we are not going to focus on them today, primarily because search engines know that they're in scope, they know who they are, and they would be more likely aware of what's going on and how this affects them. We are going to focus on the online intermediation services that are caught within the scope of this because it may not be obvious to many people that they are in fact an online intermediation service and that they need to think about this. So broadly speaking, the P2B regulation governs online platforms that enable business users to sell to consumers. So you've got three layers effectively of participants in these platforms. And just so that you know, throughout this presentation, we are going to refer to the online platforms in purple, the business users in blue, and the consumers in green. So to give you an example, and this is the most common example, we're not picking on Amazon Marketplace, but this is a good way to sort of think at a very conceptual level of what do we mean by P2B. So if you've got, for example, Amazon Marketplace, it's an online platform, you obviously have marketplace sellers, which are businesses which are using the Amazon platform, and then the marketplace sellers are selling to the consumers who are in green. The focus of P2B is not a consumer focus. The focus on P2B is that relationship between the platform and the business users. So it's the purple platform and how they're engaging with the blue business users. Why do we even need to think about this? The reason is because under the EU Digital Single Market Strategy, there is a perceived, and I'm going to emphasize perceived, imbalance between the online platforms and the influence and the power that they wield in that relationship versus the business users. Now, there is over 7,000 online platforms in the EU, but the business users depend on those online platforms in order to offer the goods and services to EU consumers. So it's this perceived imbalance in that relationship that is driving the need for the P2B regulation. The goals of the P2B regulation, as you can well imagine, is to try to balance out that relationship. So the idea behind P2B is to enhance the fairness, transparency, and predictability for the business users and to give them a bit more, for lack of a better term, power in that relationship with the online platforms. So for things like how you compare ranking practices of different providers, how business users can improve the presentation of their goods and services on those online platforms, and to have an easier and more transparent dispute resolution mechanism for the business users that may not be entirely happy with the way that the online platforms are treating them. So, having just sort of given a very high level conceptual overview, and the fact that this is about business users, particularly small and medium enterprises that sell to EU consumers, the point of the P2B is it does impose new obligations on online platforms that are in scope. So now that you're sitting there wondering, well, how do I know if I'm in scope? That's going to lead us to the next part of the webinar, and Kwan is going to talk you through what online platforms are in scope. Kwan?
Thanks very much, Judy. So the first issue is what platforms are in scope. Online intermediation services, which we've unofficially abbreviated to OIS. A service is an OIS if it fulfills these three conditions. Information service allows business users to offer to consumers to facilitate initiation of direct transactions between business users and consumers, and provided to business users based on a contract between the business user and the service provider. So in more detail, information society service. I'm sure everybody on this call knows what an information society service is. Basically, it's an online service, as opposed to, for example, software licensing. Licensing software for on-prem installation is not a service, it is software licensing, whereas some SaaS services might well be information society services. This is the most important element of the definition of OIS. Business users, who can be individuals acting in a business capacity, sole traders and so on, business users must be able to offer their goods or services to consumers, who must be individuals only, not businesses or corporate entities. And this is the crucial bit, with a view to facilitating the initiation of direct transactions between the business on the one hand and the consumer on the other hand. And it doesn't matter where ultimately those transactions are concluded. So it's with a view to facilitating the initiation, several steps removed, you might say. And there might be a question about whose view does it have to be, the business user or the platforms, both. And I'll come to that in a bit more detail when we get to cloud and hosting. But this is the intermediation element. And the final requirement, there has to be a contract between the business user and the service provider. And there are some requirements as to what has to go into that contract. And conversely, if there is no contract between the business user and the platform, then that particular service will not be caught. And the Commission has given examples of Facebook profiles, Google Search, Twitter, and Snapchat. One point about territorial scope, which is important to note. The service has to be offered to EU-established business users, which then use the service to offer to EU-located consumers. EU-located consumers. So this is very much a big expansion of territorial scope, as seems to be quite common with a lot of EU legislation these days. It doesn't matter where the platform has its own place of establishment. If its service is used by an EU business to sell to EU consumers, then it's within scope. What about the relationship between the business user and the consumer? They don't have to have a contract. They don't have to pay before it's in scope. And as I'd mentioned earlier, the transaction could be concluded partly offline. So the example is a restaurant or hotel booking platform where ultimately the consumer pays offline. And the regulation also specifically mentions that the technology used doesn't matter. It could be, for example, a voice command by the consumer. This diagram, I hope, will help to illustrate the relationships involved and what is or is not in scope. And it's not always easy to figure this out. So on the left, between the provider of the platform, the OIS, and the business user, obviously there is a contract. It's normally on the provider standard terms. That's a B2B relationship. Sometimes some platforms think, oh, well, we are B2B. It's a B2B business, so we're not in scope. But it's not the first bit on the left that you have to look at. It's the bit on the right. If the business user uses the platform to sell to consumers, then it's in scope, even if between the provider and the business user, it's B2B. It's the bottom right where it's not in scope. In other words, where it's B2B all the way along, then that's not in scope, but only that bit. If it's consumers in the chain, then it doesn't matter. The first part is B2B. The Commission has given quite a lot of examples of what it thinks are online intermediation services, and some are specifically mentioned in the regulation. So the first key example is e-commerce marketplaces. Examples, we've already talked about Amazon, but also eBay, Deliveroo, Etsy, they're considered in scope. Other examples, another main example is app stores, where the business users are the developers, who could well be individuals, who are using app stores to sell their apps to end consumers. So app stores are in scope with examples like the Apple App Store, Google Play, etc. Other examples that the Commission has given, and there are links at the bottom to the impact assessment for the Commission and studies and so on, where various specific companies have been named: Facebook business pages, Marketplace, Instagram, eBay, classified ads, etc. So, for example, SoundCloud, you can buy tracks through SoundCloud. And even price comparison websites are considered in scope where there's a contract between the business user and the platform. But there are some explicit exclusions. Online payment services are specifically excluded from being online intermediation services. There's also a specific exclusion for online advertising tools and ad exchanges. There are more exclusions or examples of exclusions given in the recitals. For example, what I mentioned earlier, if it's completely peer-to-peer without any business user, then it's not in scope. If it's pure B2B, B2B all along the chain, then it's not in scope. And again, there are some specific examples given there, such as WhatsApp, Skype, Microsoft Azure, Marketplace, and so on. SEO services, search engine optimization software services, are also not considered to be in scope. Even more examples: ad blocking software. And this is an interesting one because it just shows how broad the definition of online intermediation services is, that they actually said iOS and Windows operating systems which provide technological functionalities and interfaces, these are not in scope. So they actually said specifically operating systems are not in scope, showing how broad this is. Non-platform businesses without the crucial element of intermediation are not in scope. Again, from the Commission Impact Assessment, Amazon Retail, as opposed to the Marketplace, Spotify, etc. Now, cloud services, the Commission said without the element of intermediation, but that's not necessarily the case. And I will talk about that later on a later slide, including an article. Again, just to emphasize, licensing software for on-prem or private cloud, that is not in scope. It's not an information society service. And also, a self-hosted retail website is not in scope. If it's self-hosted, there's no platform involved. I want to also emphasize a really important point. You have to look at this service by service. You can't just look at a particular company. You have to look at whether a particular service that the same company provides is in scope. So, for example, the Commission has said Amazon Retail, where Amazon sells directly to consumers, that is not in scope. But Amazon Marketplace, which involves marketplace sellers, is in scope. And similarly for Facebook, Messenger's out of scope, but Pages and Marketplace in. Expedia, the Commission has said, the business of purchasing bulk from hotels and reselling, not in scope, but the e-commerce marketplace aspect in scope. So it's very important to look at each service separately and think, is this service in scope? Is that service in scope? And so on. I wanted to say a little bit about cloud and hosting services, because I think this could be an unintended consequence of the regulation. And there is an open access article, which I've linked to there, which you can get from the slides later on. But if cloud or hosting service is used to host an e-commerce website, which is then used by a business to sell to EU consumers, or if the service is used to host a SaaS service or a mobile app offered to EU consumers, then there is that intermediation element. The Commission said, oh, cloud doesn't have an intermediation element, but elsewhere in its impact assessment, it did actually acknowledge it could. So, there is a risk there with cloud and hosting services. Whose aim has it got to be? The cloud provider will say, I don't have an aim. You can use it for whatever you like. It's purpose neutral. It's up to the customer, the cloud customer, what they want to do with it, hosted e-commerce, website, etc. And here, I think the Commission did not intend cloud to be in scope and hosting services. The main risk is if a business user, a customer of the cloud or hosting service, turns around and says to the provider, to the service provider, this term is void because it doesn't comply with the P2B regulation, and so on. We'll be talking about the terms later. So really, for anybody falling within the cloud or hosting category, they have to think about what to do, which might depend on its own approach and risk appetite. Do you want to comply anyway if you're very conservative, or do you want to wait and see? Next topic, what exactly has to be done if you're a platform in order to comply with the regulation? There's two main requirements. One is updating terms and conditions, which includes some initial fact-finding for the information that you have to put in there in the areas that must now be addressed. And the second main area is having to update your policies and procedures. So first, terms and conditions. Now, unfortunately, the regulation has an extremely broad definition of quote-unquote terms and conditions. Basically, it's everything, whatever they're called, a term or a policy or whatever, which governs the contractual relationship between the platform and business users, and which are unilaterally determined by the platform, so the platform standard terms. Unfortunately, the fact that certain provisions could have been negotiated is not decisive to say that it's not unilaterally determined. So it's important to make sure that the transparency requirements are still complied with. And I don't think there's any great checks there. They're informational. There's no harm putting them in, even in a negotiated contract. Now, a very important point is that the terms are void unless they use plain and intelligible language. This is creeping over from consumer legislation, because at the end of the chain are the EU consumers. So this is a risk for platforms that are in scope, because business users could say, we can't understand this term, so it's void. And the aim of this requirement is so business users can properly determine the conditions for their use of the platform, when it might be terminated or suspended, etc., and have predictability about their business relationship with the platform. There is a little bit in the regulation about when terms are not considered plain or intelligible. It doesn't help that much, vague, unspecific, lacking detail on important commercial issues, misleading. So there is consumer legislation in the EU and a lot of case law on what is meant by plain and intelligible under that legislation, which is probably relevant to this legislation. So it's useful to have a look at that. What judges think are not plain and intelligible, you and I might think are plain and intelligible, so it's not necessarily what you think. But the good news is that the terms are considered to be severable to the extent that possible. Now, there's a specific list of terms that are void if they're not included. The most important, which is the most risk for platforms, is the grounds for decisions to terminate, suspend, or restrict the business user. You've got to make sure you've got all your grounds comprehensively in the terms, because you may not be able to rely on a particular ground if it's not in your terms and you want to terminate or suspend a business user on that ground. That's the biggest risk. There's a couple of other terms which are void if not included. Information on distribution channels and affiliate programs, that's transparency for business users to know through what channels their goods or services will be marketed, and information on IP rights. Again, severability. Judy, did you want to say anything about void terms at this point?
No, I think you've covered it, Kwan. The point being that, if you don't understand the danger of terms being void, you might think, oh, well, terms are void. That's no big deal. But it's actually not a good thing for terms to be void. It can have a much more significant impact on you than the term itself.
Okay, great. Thank you. Now, here's another point, which is a practical, very important practical point. Terms are also void unless they're easily available at all stages, including before the contract. The risk here is a business user is going to say, you didn't actually make the terms available to me before the contract. You didn't make them easily available to me even after we'd signed up. So therefore, they're void. And this includes things like including links in website pages, but also in apps, in email footers, etc. And there's a recital that says take account of disabilities as well. So here's the detail of what's got to be in the terms and conditions. And the list is on this page. Terminating, suspending, etc. business users, which I've already mentioned in the context of being void if not included. There are some competition, really it's more about competition related issues. Ranking for business users, goods and services in the search results, which are provided by the platform, dispute resolution, and a few others. Terminating, suspending, or restricting business users. I emphasize again, it's important to include all the grounds for the platform's decisions to terminate, suspend, or restrict business users in any way, in whole or in part. And this specifically includes delisting particular goods or services of a business user, removing their goods or services from search results, or demoting them from search results, or dimming their appearance in search results. So there's quite a broad interpretation of restriction. And while this doesn't affect validity, as is under the termination point, I would also add that it's important to include all conditions under which the business user can terminate the contract. And the regulation says that these conditions must be proportionate and exercisable without undue difficulty. So both types of termination, both ways. Now, competition type issues. The first one is if the platform or a third party that it controls offers so-called ancillary goods and services to consumers, then this has to be disclosed, including whether the business user can offer its own. And ancillary goods and services is in quotes because it has a particular definition complementary to the primary good offered by the business. So information on that has to be disclosed, on whether that's happening, and if so, what, and can the business user also do the same. Competition issues with, another competition issue is whether the platform actually provides differentiated treatment for its own goods and services, or goods and services offered by a business that it controls through the same platform, compared with the treatment that it gives to business users. And there's a list of specific things that have to be covered there. Another aspect, and this seems to be very much driven by the allegations that Amazon uses Amazon Marketplace data to actually improve its own position as a direct seller, but any technical or contractual access to platform related data that the platform, business user, and or third parties may have, and under what conditions. And this data could include consumer reviews, it could be aggregated platform data, and so on. So it's not stopping this from happening. It's not saying you're not allowed to access a dear platform, you're not allowed to access the data. It's just saying if you are accessing it, you've got to disclose it. So it's a transparency issue. And then the final point here is it's probably more to do with the platform competing with other platforms, but if it does restrict business users from offering the same goods and services under different conditions through other channels than this particular platform, then it has to be disclosed. Another important aspect is ranking, which does have a particular definition under the regulation. So when the provider allows end consumers to do searching, how are the business users' results ranked in terms of their own goods and services as opposed to the same goods and services that a different business user might be providing? So there are particular definitions for main parameters for determining ranking, including why a particular parameter is considered more important as opposed to some other parameter. However, the good news is that algorithms don't have to be included, nor information on the detailed functioning of this in order to prevent abuse. Another aspect is dispute resolution. There is an exemption for small enterprises with not many employees or turnover and balance sheet, but basically, unless the platform is a small enterprise, it has to provide information in its terms on its complaints handling system, quote unquote, all relevant information on access to the system, how it works. And also, it has to identify at least 2 mediators meeting certain requirements with whom it's willing to engage for dispute resolution with business users. So we're not talking about complaints for consumers or mediation for consumers. We're talking about systems for business users, dispute resolution with a platform. Other terms that have to be included, otherwise they're void. First one is additional distribution channels and affiliate programs. I've already mentioned that, but I would say here, it's an informational term, so what if it's void? It probably doesn't really matter. What might matter is general information on effects of the terms on intellectual property rights of business users. Now, in some cases, this is quite important for platforms, so you have to have something in. You probably already do have something in, so that may be a non-point, but if you don't have information on this, then it's void. Next point, policies and procedures. And there are 3 main areas where there will be updates needed to policies and procedures. The first is future changes. How are you going to change your terms and conditions for business users in future? Second is how you are going to terminate, suspend, or restrict, and indeed reinstate business users in future. And finally, on dispute resolution for business users. So on this first point, future changes. Now, this is very important. Substantive as opposed to merely editorial updates to terms and conditions have to comply with certain requirements. Otherwise, they are void. They are void altogether. The main condition is that you have to give at least 15 days notice. A lot of platforms probably do this anyway, but the notice has to be longer than 15 days as quote unquote reasonable and proportionate in the circumstances, with some exceptions where no notice needs to be given or less notice needs to be given. Now, how do you work out what's reasonable and proportionate in the circumstances? What the regulation specifically mentions, for example, if the change would require business users to make technical or commercial adjustments to their goods or services or their coding, etc., then you might need more than 15 days. But it's going to be tough to figure out what's reasonable and proportionate in a particular situation. There's also a trap in that the notice of the future changes has to be given, again, borrowing very much from consumer law, in a durable medium, something that the business user can store and keep unchanged. So this means that a link to a web page may not be good enough because you could actually change the web page. You might need to actually include something as an attachment or in the body of the email giving notice. Another point to do with future changes is that it is possible for a business user to waive the notice through a statement or clear affirmative action. Data protection lawyers, that sounds pretty familiar. Or if they submit goods and services after they've received notice of the change, except where more than 15 days notice is required because of commercial or technical adaptations, etc., that are necessary on the part of the business user. In that situation, submitting further goods and services is not waiver of notice. Also, the business user has the right to terminate the service after receiving this notice of changed terms. Next main point is about the procedures and policies of the platform for terminating, suspending, etc., business users. And it will be important to try and record, considering the decision, for example, could it have just delisted individual goods rather than terminating the service altogether, and what are the reasons, etc. Kind of a form of accountability. Major point, the business user has to be given a statement of reasons for this decision to terminate, suspend, etc., with some exceptions, and an opportunity to clarify the situation through the complaints handling system. And again, the notice of termination, restriction, etc., has to be given in a quote-unquote durable medium. There are also points about the timing of the prior notice, again with some exceptions where no notice is required. For restrictions or suspending individual goods or services, that can be at the same time or before it takes effect. The restriction or suspension takes effect. But if terminating with related deletion of the business user's data from the platform, it has to be at least 30 days, again with some exceptions. Next, dispute resolution. Now, there has to be a free to business users complaints handling system for business users, and there are obligations in the regulation for the platform to consider complaints, speed, etc., etc. Again, exception if small enterprise. This is without prejudice to either side's right to litigate. Furthermore, it's important to bear this in mind because of recording things. Platforms have to effectively publish a report on the effectiveness of a complaints process, at least annually, with a lot of information like the number of complaints, types of complaints, time period, etc. And this report has to be easily available to businesses. So this affects compiling the information needed to produce the report at least annually. Next point about dispute resolution is mediation. Again, with a small enterprise exception, and again, without prejudice to either side's right to litigate. So the platform will have to decide which two mediators it wants to identify in the terms. How's it going to handle requests from business users for mediation, or for a different mediator from one that's identified in the terms? How's it going to handle the mediation process itself? Record information on mediation attempts, because again, business users have the right to request information about the effectiveness and functioning of the mediation process. So let's end with a checklist of actions for platforms that are in scope. And the first really is which services are in fact in scope or borderline. Because if they're borderline, do you want to comply or do you want to wait and see, and so on? And this is, of course, all by 12th of July, which is not far away. You've got to do your fact finding to find what information you need to actually put in your terms, the transparency information. You've got to update your terms for affected services, and then, of course, also update policies and processes for changing the terms, for terminating users, for handling their complaints and handling their mediation requests. And finally, monitor what the position is going to be for national penalties and enforcement, because enforcement is actually up to the individual member states. Even though this is a regulation, member states are supposed to enact their own national enforcement measures. So let's see what happens on that, which member states are more risky or not. So far, to be honest, and particularly with the COVID crisis, not much has been happening on that front. And of course, monitor for the position in relation to mediators as well, because the Commission is meant to encourage mediators that are compliant with the regulation. So just to mention, the Commission was supposed to issue guidance on how you comply with the ranking requirements, the ranking transparency requirements. Initially, they said end of April. Now, the latest I've heard that they've told me is early July. The good news, hopefully good news, is that they've said they're also going to issue questions and answers covering quote unquote every aspect of the regulation. So hopefully some of the uncertainties will be addressed in that. They also may, and I'm not sure entirely, but they may be issuing information on the national implementations by various member states as well. Of course, I've already said, bear in mind, keep an eye out for national implementations. I should mention that under the regulation, representative bodies, for example, SME industry associations and public authorities could actually be authorized to take action for non-compliance under the regulation. So there's the risk of action by those bodies as well, not just by business users individually. And I've already mentioned mediation services. Keep an eye out for those. Here, again, you'll be getting the slides later. Here's a list of some resources about this regulation. And that is the end of our presentation. Thank you very much. Has anybody got any questions or any points they want to raise?
I think we've had a question that was already submitted. Let me just see. The question is, what are the implications from a GDPR perspective of the use of these platforms, in particular when it comes to the client exercising their rights? Well, I think as we sort of pointed out, the P2B regulation doesn't really deal with the consumer aspects, and that's where the GDPR comes in, but really deals with more of the aspects of where how the platform interacts with the businesses and the terms and conditions on which the businesses engage with the platform. Is that, I know that's not quite the answer to the question that you might be looking for. So whoever answered that question, if there's a follow-up, by all means, please do submit it.
I would add, I've brought it back to the slide on access to data. That I think is the main interaction with the GDPR, because you have to, platforms have to disclose any technical or contractual access to platform data. So I think that particular term, that particular transparency term, has to be checked with the data protection and privacy lawyers to make sure that whatever is disclosed here is consistent with the platform's position under its privacy notice and its agreements. Obviously, it's important to make sure that they are not going to, this is not going to cause trouble. Disclosing something here is not going to cause trouble on the privacy and data protection front. I think that's probably the main area of interaction. Any other questions? Shall we go to, there was a question about, does the regulation apply to transport businesses and postal operators offering their services via a website? If the service is offered to businesses to enable them to sell to consumers, then yes, it would apply. If it's, but that, again, I don't know who asked that question, but if you're talking about offering services via a self-hosted website, then you're fine, because it's not a platform. And actually, if you're talking about delivery services, this is a post. Remember, the element is to facilitate, with a view to facilitating initiation of direct transactions. A delivery service, if that's what you're talking about, is post that. If there was a platform saying, hey, use this particular delivery service and enter into a transaction with this delivery service, might possibly be an ancillary service, but that's not the same as an online intermediation service, if that helps.
Okay, we've got one other question submitted here. With regard to practices limiting businesses' freedom to offer better conditions outside the platform, if these restrictions, narrow MFNs, for example, are already set out in the contracts, what more needs to be done? I'm assuming MFN is most favored nation clauses. So let me just sort of repeat the question. With regards to, quote, practices limiting businesses, quote, freedom to offer better conditions outside the platform, if these restrictions, narrow MFNs, for example, are already set out in the contract, what more needs to be done? So I guess the question is, if you already have set out in the contracts restrictions like MFNs, do you need to do more under the P2B regulation in regards to complying with this, setting out the practices limiting the business's freedom to offer better conditions outside the platform?
Yes, I would add here that, again, I just kind of skated over that particular term. If you have to, if you do restrict this ability to offer through other channels, you have to include the grounds for that restriction as well, and make those grounds, quote unquote, easily available to the public. And that means the main, and I know in practice it's not going to be easy, but the main economic, commercial, or legal considerations for those restrictions, your justification for doing that. So not only do you have to include the restrictions, but you have to say why you're restricting. And of course, you have to comply if it is a platform, an online intermediation service within the definition of the regulation, then of course you have to comply with all the other requirements of the regulation as well. Is there another question? Yes, that's another question, isn't there? Is the consumer element satisfied if the relationship is B2B, but the service is for the benefit of a consumer client? I'm not quite sure what is meant here by for the benefit of a consumer client. It is, in a sense, it's broad, but in a sense, it's narrow, because it has to be, and again, that intermediation element, with a view to facilitating the initiation of direct transactions between the business and the consumer client. So if this is helping a consumer client, but it's actually not with a view to facilitating the initiation of a transaction between the business and the consumer, i.e. usually selling something to the end consumer, then it's not an OIS. I hope that helps. There has to be that element of, allowing selling effectively, or direct transaction between the business and the consumer at the end. There seem to be more. Oh, great. Okay, so that makes sense. There's another question, isn't there? So I'll read that out. Do I understand correctly that businesses providing services to a platform would not be EU business users providing services to a customer, e.g. a video chat function? If platform has a video chat an outside business provides, that is not facilitating a direct transaction. Yeah, that's right. If you're providing services to a platform, as long as that's not with a view to the platform initiating a direct transaction with a consumer, of course, then it wouldn't be caught as an OIS. I mean, there are lots of that's why I did that diagram earlier on. There are lots of possible aspects here. I don't think I covered all of them in the diagram, but services to the platform itself would not be in scope unless it's actually with a view to facilitating. And there is another question about, does the transaction have to be consummated or just targeting? And of course, this is an intermediation element here, with a view to facilitating. With view is very much like you don't actually have to have consummated the transaction, but you're aiming to to facilitate the initiation of direct transactions through the platform. Okay. Another question about hosting and cloud providers. If a managed support provider provides a support service for a platform or hosts the platform, and the customer is a business but provides service to consumers, does the MSP or hosting business need to account for the regulation? A support service maybe is less directly relevant, but if you're hosting a platform that allows the customer to initiate direct transactions with business users, it could be. It just does depend on the actual situation. I mean, I think that most are e-commerce website used to sell to consumers. If a business uses a third-party platform to host its e-commerce website to sell to consumers, or if a business uses a platform to host a consumer SaaS service or mobile app, then the platform could be in scope. As I say, I don't think that's the intention of the commission, but there is the risk of business users, the customer, saying, this term is invalid because you didn't give me enough notice, or it's not intelligible, etc. Okay. I hope that answers that question.
Yeah. We have now run out of time, and I know there's a few more questions. We will get the questions to you. We will also be sending you a copy of the slides and the recording. So notwithstanding the technical issues, we appreciate your attention. We appreciate your questions, and we appreciate you attending today. If you have any more questions and want further information, please, by all means, reach out to Quan or me. And on behalf of the entire privacy team at Phil Fisher, thank you all very much.
Thank you.